The Dobbs draft leak investigation is now complete. Or is it? Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Yesterday afternoon, the Supreme Court of the United States issued a report of its investigation into the leak of Samuel A. Alito's first draft opinion in Dobbs v. Jackson Women's Health Organization. The Dobbs draft leak. Unfortunately, the Marshal of the court concludes that we may never know who leaked that draft. The Marshal admits that the Supreme Court simply does not adequately protect its confidential and court-sensitive information and trusts too many people too far. Sadly, this includes court members themselves, though the Marshal never says that. But from what the Marshal does say, one can readily see how some justice, or his or her clerk, could have done the Dobbs draft leak. Before I review the history of the Dobbs decision, break down this report, and explain that provocative statement I just made, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, especially this t-shirt that I have chosen for today, which reads, "I need new conspiracies, as all the old ones came true." One more thing. If you like what you're about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, do you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click that and leave me a tip. Any currency will do, so long as it's legal tender. Now then, the case of Dobbs v. Jackson Women's Health Organization, 597 U.S. fill in the blank, 2022, reversed 49 years of ultra-permissiveness on when and under what circumstances a woman could end a pregnancy. I have a link in the description to that case. And as for the fill-in-the-blank, the law book publishers will literally fill that in when they have the book in galleys and can assign a page number. In 1973, the court held, Roe v. Wade, 410 U.S. 113, essentially that a woman could end her pregnancy voluntarily for any reason or no reason until the unborn child became viable. A later case, Planned Parenthood of Southeastern Pennsylvania v. Casey, 505 U.S. 833, essentially said that the Roe case stands as decided. Ever since then, several states watched carefully the ideological balance of the court. This should never have become a thing, but after McCulloch v. Maryland, Thomas Jefferson would observe that the court itself made the Constitution a mere thing of wax. Nevertheless, states would try to regulate pregnancy ending on simple sanitary grounds, or they would try to set time limits on the procedure similar to those in nearly every other Western country. And the court refused, and refused, and refused. That refusal explains in part why Texas passed its Heartbeat Act and relied on private citizens to bring civil action against pregnancy-ending practitioners. Then, in 2018, Mississippi passed its Gestational Age Act to cut the procedure off after 15 weeks. The Jackson, Mississippi Women's Health Organization sued Mississippi in federal court. They won at the district court and in the 5th Judicial Circuit. Thomas Dobbs, the Mississippi Health Commissioner, petitioned the U.S. Supreme Court for review in 2020. The case came to oral argument on December 1st, 2021. That's docket number 19-1392, and I have a link in the description to the docket listing. The respondents, in their briefs and at argument, probably made a rhetorical mistake that cost them their case. Judith Reichelman, attorney for the respondents, insisted on the Roe standard and stood on a basic right to end a pregnancy. Furthermore, she refused to concede that 15 weeks was a reasonable time limit. Chief Justice Roberts said, and she did not contradict him, that this time limit applied in many other countries, no matter. Amy Coney Barrett pointed out that safe haven laws, and every state has one, can relieve a woman of the burden of motherhood, again, no matter. But Clarence Thomas asked her whether her stand on bodily autonomy would let a woman skate on taking alcohol or other drugs before viability, and she was not willing to assert that, and that one thing made her position logically inconsistent. Now, what happened after Chief Justice John Roberts submitted the case at the close of oral argument? One can only speculate. Doubtless the court held a preliminary vote. That vote must have come down 6-3 in favor of Commissioner Dobbs, but 5-4 in favor of explicitly overruling Roe. We do know that Samuel A. Alito produced a first draft opinion of the court dated February 10, 2022. Furthermore, the court accepted no further briefs, but the court did accept a letter from the new Solicitor General of Virginia, disavowing an amicus or friend of the court brief in which Virginia had earlier joined. This was the California brief, submitted September 20th, 2021, supporting the respondents. Now, on May 2nd, 2022, Politico.com published a copy of Samuel A. Alito's opinion. That was the Dobbs draft leak. The news hit the country like a thunderclap because Alito clearly said he would overrule Roe and Casey both. Now, do you remember what I said about the Dobbs draft leak when it happened? I told you what I thought, that most likely the leak was a fraud. But Chief Justice Roberts certified that the Dobbs draft leak was authentic. He also called for an investigation by the Marshal of the court. That leak must have prompted some on the pro-choice side to think that they could change the court's mind. An organization calling itself ERA-NC Alliance, the NC stands for North Carolina, actually tried to file an amicus or a friend of the court brief on May 16, 2022. The court refused 4 times to file even a motion begging the court's leave to file such a brief so late. The Chief Justice insisted that the document was only a draft and was not final. Nevertheless, when the judgment came down, it mirrored almost exactly the Dobbs draft leak. The only differences consisted of a minor change of phrase and acknowledgments of dissenting and concurring opinions. Yesterday, the court released a 23-page statement by the Marshal of the court. Together with Michael Chertoff's group, I have a link to that statement in the description. The statement covered the Marshal's investigation of the Dobbs draft leak and Michael Chertoff's opinion that the investigation was thorough. Mr. Chertoff served as Secretary of Homeland Security in the George W. Bush administration, the second to hold that post. In essence, the Marshal says, we cannot know who leaked that draft. That is, no one can establish by a preponderance of the evidence who leaked it. The Marshal did find it unlikely that any outside person hacked the court's servers to get that hard copy. So the Marshal focused her full attention on the court's clerks and temporary and permanent staff. But the Marshal did not discuss any suspicion of any of the court's members, though she did repeat the canon of judicial conduct. The Marshal admitted many weaknesses in the court's protection of sensitive information. Members and staff of the court trust one another, so the court has limited safeguards for its very sensitive information. Furthermore, and this could be the key, the pandemic of the virus that shall remain nameless prompted the court to let more staff work at home. They even issued printers to some staff, and investigators tried to tease out printer logs from one such printer without success. In brutal fact, and I quote, "It was too easy to remove sensitive information from the building and the court's information technological networks, increasing the risk of both deliberate and accidental disclosures of court-sensitive information," unquote, the Marshal of the court. I am now going to get into the security weaknesses at the court, which the Marshal highlighted, both human and technological. But first, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges, but if you're like me many years ago, you don't know where or how to start. Now, Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, either way, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy to your future. Court staff, and especially law clerks, understand that they are handling confidential information. The court's Human Resources Manual and Law Clerk Code of Conduct reinforce this idea. So does the Judicial Code of Conduct. Furthermore, this applies to someone leaving the employ of the court. A law clerk especially receives instructions not even to tell a spouse what goes on in the court. But clearly, several employees did. That came out in the investigation because they had to swear that they had told their spouses, but no one else. Aside from the human security weakness that someone is lying without shame in this matter, the Marshal highlighted the information handling weaknesses. Among other things, the court's computer systems are out of date and will see an overhaul. I have worked with networked and standalone computers since the first appearance of the first desktops and portables, the ones that were portable like suitcases. This includes working with locally connected and networked printers, also called print servers. I also have training and or experience with database administration and management, reading of error and event logs, and cybernetic security. So I am going to give you my evaluation of the Marshal's report as an experienced organizational information officer. Investigators don't believe or don't want to believe that anyone hacked the court's network or any server on it from outside. Nor do they believe that anyone with senior administrative privileges accessed or moved the opinion. The draft opinion had a rubber stamp on it, noting its first draft status and the date of circulation. Every public court document is a PDF document. PDF documents can come from word processing programs with PDF export options, print routines that offer save as PDF among available print devices, and the key here, scanners. A document carrying a rubber stamp almost must be a scan, but we don't know. 82 individuals, besides the justices, had access to Alito's opinion. We know who emailed the document to whom, with authorization, but did any recipient email the document to anyone else without authorization? We have no way to tell. Limitations in the court's computer record keeping, the Marshal says. Could they look at the event logs? Many of these logs do not even exist. 34 individuals admitted printing out hard copies, and 4 were not sure whether they did or not. And many of them admitted that they did not give the draft opinion the consideration that sensitive information deserves. The Supreme Court still uses locally connected printers in addition to network printers. Now, local printers notoriously forget what jobs they've handled beyond the most recent 60. Network printers can generate logs, but the court's networks weren't keeping them. The court issues laptop and tablet devices, but not smartphones, to its staff. If the investigators asked for call and text details and billing statements, all employees provided them. But again, the information was limited. Clearly, the court would have done better to issue smartphones to its staff for court business only. Interviews revealed that some staff told spouses or similar significant others about their work generally, or about the Dobbs case, and some admitted handling the Alito draft in ways not up to the court's usual standards. Speculation on motives for the Dobbs draft leak were rife, of course, even to naming some law clerks. Investigators found nothing to lend credence to any such speculation. So they say. So what do we have? First, let me say that as an experienced information officer, I am appalled, stupefied, horrified, or in plain monosyllables, shocked by what I read. But sadly, not surprised. You see, I also have experience of the computer networks in Veterans Affairs hospitals from my days as a pathology resident. And I can tell you, those systems were out of date for their day. The Marshal has convinced herself, and probably with perfect justice, that this was no hack. It was an inside job. Either that or carelessness of a phenomenal order in leaving a copy in a public space. Whoever did the job, if job it was, got away with it because court security was lacking. The Marshal named 2 key areas of vulnerability: movement of hard copy documents from the courthouse to the homes of staff or court members, and no way to track print jobs on court printers or copiers. Nor, sadly, were these all. So, under the heading of locking the barn door after the horses bolted, the Marshal recommends, first, limiting the number of people with access to court-sensitive information and the printing of hard copies. Second, writing a universal policy on the handling of court-sensitive information. Third, developing a better method of destroying court-sensitive documents when appropriate. Fourth, overhauling information security and especially the handling of case-related documents. Fifth, installing better print and copy logging and tracking mechanisms. Sixth, laying emphasis on confidentiality during training. And 7, supporting legislation to make any such future disclosure a federal offense. To that, I would add, issue smartphones to court staff for court business only. Make them Bluetooth pairable for calls and alls only. And make plain that driving to or from court is an extension of one's duties at the courthouse, with all that goes with that. And also, do not let them have near-field communications ability. Do not let them connect their smartphone to any device other than a court device. And do not let them add contacts. If they need contacts on their court phones, let them see their supervisors. And do not grant them access on their court phones to social media. The public is treating the Marshal's report on the Dobbs draft leak with open scorn. For example, Charlie Kirk broke the story on Twitter. I have a link to that tweet in the description, and a link to his tweet saying that we can find grandmothers who entered the Capitol on a certain day to take selfies, but can't find someone who stole and illegally shopped a Supreme Court draft opinion. A thing Charlie Kirk does not believe. One person in reply referred to his earlier article of last fall. He repeated his opinion that the Supreme Court knows exactly who is responsible and doesn't want to name him. I have that link in the description. One person seemed to speculate that Justice Stephen A. Breyer was the source, and his motive? Revenge for someone forcing him to retire to permit the elevation of Ketanji Brown Jackson to the court. Again, link in the description to the tweet. Now, where am I? 4? Yes. The 5th one is from a user who suspects the Chief Justice, who wrote his concurrence after seeing the public reaction to the leak. And last, I have a link to a tweet from someone who suspects a clerk for either Elena Kagan or Sonia Sotomayor, in which case the Chief Justice actually wants to protect that clerk's reputation. Almost no one suspects a conservative justice because such a justice would have no apparent motive. In fact, we might never know. Either one of the justices sprung this leak, which seems incredible, or someone, perhaps even a law clerk, lied without shame. They did this because the court was far too trusting in its handling of confidential information. Security is about whom you trust, how far, and with what. The Supreme Court trusted people too far. In fact, the novelist Michael Farris, who wrote Anonymous Tip, before he became an advocate for an Article 5 Convention of States, suggested that the court trusts its clerks too far. Maybe, and sadly, that goes for the court staff. Links in the description of the article, to the Dobbs decision, to the docket listing on that case, to the Marshal's report, to 6 tweets giving public reaction to that report, to my Declarations of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and to ourcivilized.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to this channel and links to my road leak playlist, my video from when the Dobbs decision came down, and any other video I can find giving further insight into this report. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.